Preparing a successful US waiver application, Form I-192, is a challenging process. In this video, I'm going to share 5 must-know tips that will help ensure your US waiver application has the very best chance of being approved. I'm Dan Joffe, US Waiver Lawyer. If you're looking for expert advice on traveling to the United States without stress, schedule a free call with me using the link in the description below. Let's get started. First, it's important to understand the decision-making process for I-192 waivers. The Admissibility Review Office, which is part of US Customs and Border Protection, known as the CBP, is the decision maker regarding whether your US waiver application is approved or denied. This is a discretionary determination. That means even if you technically meet eligibility requirements, the CBP can still deny your waiver if they conclude you don't merit approval. Their decision involves consideration of both positives and negative factors from your application and background. The CBP has broad discretion in making this judgment call according to all the criteria. Next, it's important to understand the eligibility criteria for a US waiver. The CBP uses standards that are set out in the matter of HRANCA, which is a Board of Immigration Appeals case. At a minimum, the CBP will consider the seriousness of the underlying cause of your inadmissibility, the risk of harm to society if your application is approved, and the nature of the reason for wishing to enter the United States. The CBP will also consider other factors such as what your offense was, the circumstances that led to your offense, how recent your offense was, whether it was isolated or part of a pattern of misconduct, and evidence of your rehabilitation. Crafting a strong legal argument around those points is critical to getting your US waiver approved. Now, at our law firm, we have the legal criteria, and what we do is we apply the same legal framework to prepare your application, maximizing your chances of success. If you need help with your waiver application, reach out to book a call with me. Another key tip is avoiding common pitfalls that can sabotage your I-192 application. A big mistake we often notice is the oversimplification in preparing the Form I-192 application. Essentially, we see applicants treat the application process as if it were as straightforward as filling out a basic form, which is not the case. A successful US waiver application requires you to craft a compelling legal narrative explaining why you merit a waiver despite your history. Now, every detail must be covered thoroughly, from evidence to statements demonstrating your reformation and rehabilitation. Be very careful and be deliberate in your preparation because mistakes can lead to denial. And when compiling your application, carefully check that you have all the required documents before you submit your application. Check out the CBP website for a complete list. Missing items will delay or jeopardize your application. And as discussed, make sure that your waiver application includes a convincing legal argument that meets all of the CBP's criteria. Finally, be aware of the timelines involved. Application preparation may take weeks to months depending on your situation's complexity. Gathering records like court documentation just takes time. Once submitted, CBP processing time really can take anywhere from a few months to 6 months. The variability depends on their workload, your inadmissibility severity, and response times from CBP external inquiries about your waiver application. Given the uncertainty regarding timing, you should avoid booking a definitive travel plan until you get an answer from the CBP. If you need help preparing with your US waiver application, reach out to schedule a confidential free call with me. The link is in the description below.